I'm not threatening you. Say one more word, and that's 30 days. 30 days.
Hey, what's going on, guys? Welcome back to Sovereign Citizens Hall of Fame with your boy TP. Today, for the first time, we will be courtroom hopping into the courtroom of Judge Terrance Holmes out of the state of Texas. And from what I hear, Judge Holmes has a sovereign citizen before him that has a whole lot to say. And I also have heard through the grapevine that there are some intense moments in this proceeding, a little bit of some slow moments in this proceeding, but nonetheless, this is our first time in this judge's courtroom. He has a sovereign citizen before him, so it's our duty to go ahead, sit in, listen, and hear what they both have to say. And with that being said, guys, if you're not ready, I am, so let's go ahead and jump into this proceeding.
Jefferson County Court at Law number 2 is in session. The court is in session in 2 cases. Cause number 24 CCCR 2816 and cause number 24 CCCR 2817. Both cases are styled the state of Texas versus Helen Kathleen Reyes. And we have Ms. Reyes, who is present in court. Ms. Reyes is pro se on January 28th of 2025. Ms. Reyes signed a document that is titled Waiver of Counsel for Purposes of Entering a Guilty Plea or Proceeding to Trial. Is that correct, Ms. Reyes?
Yes, sir, that's correct.
And Ms. Reyes has filed pretrial motions, and we will have a pretrial hearing on Ms. Reyes' motions. The state is represented in this case by attorney Andrew Huber. And Mr. Huber, how are you doing?
Doing well, Judge. Thank
And
you.
Ms. Reyes, how are you doing?
Very well, thank you, sir.
That's good. Now, Ms. Reyes,
Yes.
I have two, we have a motion that was filed on February 25th of 2025. The motion is titled motion for challenge to subject matter and in personam jurisdiction. And I see in April 11th of 2025, you filed a motion for challenge to subject matter and in personam jurisdiction. Is that correct?
Yes, sir, that's correct.
Okay. Now, would you like to proceed on your motions at this time?
Yes, in due respect, I haven't received any written correspondence from the state regarding my motions. So I'm not sure.
Okay, when you say written correspondence,
Yeah,
what do you
means that
mean?
they need to answer my motions.
And that's what this hearing's for.
Yeah, well, I need that in writing
Okay. So,
to
Ms.
give me time to be able to respond accordingly.
They
purpose
can-
of starting the motion.
They are, see, the purpose of the hearing is for you to present your motion. And the state, if they don't have a written response, they can respond to your motion.
But I would like it in writing as well.
Okay, well, that's, at this time, the hearing is for you to present your motion. Okay, so so at this time, you can go ahead and present your motion.
So at this time, my motion is that comes now Helen K. Reyes, appropriate persona as defendant in error in this matter. And I assert the following, that the appellant defendant Helen K. Reyes in error asserts all her unalienable rights, privileges, immunities at natural law, common law, and maritime law, and all of her commercial rights relevant to the state. At this time, the defendant objects to and does not consent to any assignment or any referral of this case in any part to any decision maker other than a duly elected or properly appointed judicial officer exercising full authority of a municipal court judge or county court judge, and who has an active and current oath of office on file. Now, I object to the use of unpublished cases and a reference to materials not publicly accessible. As far as my motion, of course, I do have my table of contents, such as my motion for subject matter jurisdiction challenge, assertion of rights, objection to non-judicial decision-making, objection to use of private law, legal basis for granting challenge to subject matter jurisdiction, multiple grounds of judicial and prosecutorial misconduct and errors, open act of sedition, constitutions do not apply, judgment is not consistent with existing law, no such offense defined within Texas law, and statutes do not require two simultaneously functioning headlamps or define any such offense. So in my previous case, the judge refused to allow the defendant to address my constitutional challenge to certain provisions of Texas Penal Code at 38.02 and Texas Transportation. There was no certified transcript provided. Of course, my violations from the judicial and professional ethics on previous court, and then court cases that follow with state statutes and Texas constitutions. So at this time, I'm the respondent, and I request that the court to grant motion for the new trial. So the legal basis for my challenging. So the appellate court lacks the subject matter jurisdiction because the trial court never properly acquired and maintained the necessary subject matter jurisdiction required. As far as that, the complaint alone does not invest that court with the jurisdiction pursuant to Article 27.01 Code of Criminal Procedure. The primary pleading by the state in all criminal actions is an indictment or information. And nowhere within the Constitution or statute is there any such language relative to a criminal complaint. It is an inarguable that at Article 27.01 Code of Criminal Procedure, unlike the current judicial interpretation of Article 45.018, is constitutionally and legally consistent with the Texas Constitution, Article 5, Section 12B, Clause 4, relative to indictments and informations being the only primary pleading of the state that invests a court with jurisdiction of cause. Nowhere within the Texas Constitution or codified law, which would be constitutionally invalid if it existed, is there language that refers to a criminal complaint as a primary pleading and a criminal action on the part of the state, or as an instrument that invests the court with jurisdiction of the cause. In short, neither the original writers of our state constitution nor the Texas legislature ever considered an unsworn criminal complaint as being such an instrument. The language of Article 45.018A is, for all intents and purposes, virtually identical to the language of Article 15.04 Code of Criminal Procedure, and that both statutes contain the language that is a complaint and an instrument charging a person with an offense. But there's no argument whatsoever amongst the courts and prosecutors that an indictment or information is still required to be prepared and signed by a county or district attorney acting in their official capacity relative to any complaint filed pursuant to Article 15.04. The only essential difference between Articles 15.04 and 45.018 of the criminal procedure is the unconstitutional interpretation of Article 45.018A that allows for a criminal complaint to be used as a total replacement for the constitutionally and statutorily mandated information or indictment, and the utterly illogical and incorrect belief that a complaint can invest a court with jurisdiction entirely on its own, despite the specific requirements mandated by the Texas Constitution. The jurisdiction is invested only by means of an indictment or information. This unconstitutional and illegal interpretation of Article 45.018A Code of Criminal Procedure was fabricated out of thin air entirely by judicial fiat and the prohibited act of legislating from the bench. Meanwhile, the interpretation of Article 15.04 Code of Criminal Procedure has more or less been correctly and consistently read and applied in compliance with the requirements set forth. Article 5, Section 12B, Clause 4, Texas Constitution, and Article 27.01, Code of Criminal Procedure. Therefore, defendant asserts and alludes that the obvious reason that such is the case is so the legislature and the courts can knowingly and willfully engage in the unconstitutional and illegal acts listed later in the section of this document. And they do so to the utter disregard and detriment of the due process rights of those who stand accused of any Class C crime-only offenses. Pursuant to Texas Constitution, Article 5, Section 12B, Clause 4, an indictment or information invests a court with jurisdiction of the cause. Nowhere within the Texas Constitution does the term complaint even appear. The closest possible reference would be that of a sworn statement or affidavit, which a criminal complaint most certainly is not, considering that a criminal complaint in Texas fails the legal definition of what sworn actually means, which requires that a person with firsthand knowledge be the one signing the instrument and that they are doing so under penalty of perjury or punishment from some higher authority. However, in the state of Texas, a criminal complaint is not required to be sworn, which means the instrument must bear a proper jurat, stating that it is being signed under penalty of perjury by a competent fact witness as the affiant. In order to avoid the penalty of perjury or punishment by a higher authority, the signatory of a sworn instrument must have competent first-hand knowledge of the facts alleged in the instrument being signed and know that the facts are really true and correct. In contrast, criminal complaints are signed using nothing more than a statement. I have reason to believe and do believe, which is an extrajudicial oath carrying no penalty for being made falsely. It is not a judicial oath made under penalty of perjury or of other punishment for a higher authority or the eyes of God when attesting that the statements and allegations are actually true. The former oath is based merely upon someone's unsubstantiated belief or outright hearsay. Something illegal may have occurred at some previous point in time. While the reasoning for not requiring that a criminal complaint be filed by a person with firsthand knowledge is both understandable and worthwhile, to at least initiate an investigation into the matter alleged. Such reasoning cannot be the basis for ignoring constitutional and due process requirements for protecting the rights of those being accused, no matter how beneficial its actual intent, especially when the only complainant and supposed victim is an officer or employee of the government itself in some quasi-criminal jurisdiction and proceeding that no constitutional or statutory language ever created or even recognizes as being a valid form of jurisdiction. There's a very real legal difference between signing an official government document based upon I have reason to believe and do believe the facts asserted herein are true and correct, versus I certify under penalty of perjury or other form of punishment if the facts asserted herein are true and correct. And the latter carries a heavy penalty against the signatory for making false statements and allegations, while the former offers absolutely no protection whatsoever from false allegations to the person being accused. This is violative of yet another basic principle of substantiative procedural due process, that it is actually required by Texas law that an independent judicial determination of probable cause be made that is based upon the presentation of actual facts and supporting evidence, not mere belief. And that protection is being set aside and ignored as an inconvenience to the injustice system whenever a criminal complaint alone is allowed to be used as a charging instrument that invests jurisdiction in the court. The defendant argues that there is only one logical reason for the legislature and the courts to try to circumvent and nullify the requirements for properly and legally investing a court with jurisdiction as required by the Texas Constitution.
If I may, Your Honor, I believe the defendant in this case is attempting to read the entire 40+ page motion into the record.
Okay. Let's do this here. Normally, when we have motions, we have the written motion right here. We
Sure.
already have that. And what you can do is argue, if you're not present any fact, any evidence, you can argue why or why not the points in this motion should be granted. You can argue
Yeah,
point,
I'll argue it.
point by point.
So
Okay,
basically,
but the other thing is, make sure that you speak up,
sure,
because the court reporter was having a little bit, some difficult time listening to you, okay? So at this time, you can proceed with your arguments.
So my argument is that the complaint itself doesn't vest court with jurisdiction, subject matter jurisdiction.
Okay,
Because number one, it doesn't provide all of the facts from the time that I was pulled over on the side of the road. So basically, they stated in their complaint, they restated what the statute stated, correct? However, they didn't go into all the specific elements within that complaint that would be required in order to give the defendants timely and sufficient notice of the actual offenses that were occurring at the time of the officer's decision to, emergently pull over the defendant. So that's one of the things that stands out because, I'm pulled over, emergency lights are engaged. Okay, that's an emergency. At that point, I'm under custodial arrest. I immediately pull over. I don't know what this was for, because I'm going a normal limit down the highway. It's clear. It's a cool night, about 38 degrees. So I don't know what's going on beside myself. I'm pretty much the only person that I notice on the roadway. So I don't know what hazard I was causing at the time, right? So I got pulled over. I've been told that my headlamp was defective. Well, I could see just fine. I've got atmospheric lighting. How could the cop see my car if my lighting was defective? Because apparently there was enough light to see my car. So his complaint is unsubstantiated
okay,
on that point.
okay. Now let me do this.
Sure.
To that point, Mr. Huber, do you have a response?
Yes, Your Honor. Just first taking, I think there are several points made here. The first one being to subject matter jurisdiction. And generally, municipal courts have jurisdiction over offenses involving Class C cases. And contrary to Ms. Reyes' argument, complaints do vest jurisdiction in municipal court in these kinds of cases. They're not, as she asserts, a concoction of the legal system to circumvent one's rights. And in this case, the complaints do articulate with sufficient detail the offenses at hand. The one being defective headlight, and the other being a failure ID. And if the court would like, I can read into the record specifically what the complaints state in those cases. See, in regards to the headlight case, it states that on or about January 28th to 2024, did then and there unlawfully drive and operate a motor vehicle upon a public roadway to wit Magnolia Avenue, at its intersection with 12th Street, therein situated during a time at least one half hour after sunset and at least 1/2 hour before sunrise, or when light was insufficient or atmospheric conditions were unfavorable so that a person or a vehicle on the street was not clearly discernible at 1,000 feet away, without having at the front of said motor vehicle at least 2 lighted headlamps, one on each side of said motor vehicle, mounted at a height of 24 to 54 inches, contrary to sections 547.302 AC, 547.321, and 541.4015 of the Texas Transportation Code. That complaint is very specific about the conduct in which Ms. Reyes is being charged with, and in the statement in this complaint was signed, sworn, and subscribed to May 31st of 2024 through information provided by the arresting officer or the stopping officer in this case.
Okay.
And then in regards to the failure to ID case, similarly, it states on January 28th, 2024, that the defendant was operating a motor vehicle and was lawfully detained by a peace officer for an alleged offense of a law and failed to provide or display defendant's driver's license on the officer's request for the license, and intentionally refused to give defendant's name, driver's license number, residence address, or date of birth to peace officer on the officer's request for that information, contrary to section 38.02 of the Texas Penal Code. So both complaints in this case are articulate very specifically the conduct that she's charged with. Furthermore, what the defendant prays for in this motion is for a new trial, and that's exactly what she's getting here. She's appealed the case to this level, and at this point, we give them a trial de novo on this case. So the court below did have subject matter jurisdiction. The complaint did best such jurisdiction in the municipal court. The complaints are valid and articulate the necessary facts in this case to relay that information to Ms. Reyes, and what she's praying for in this case she already has.
Now, Ms. Reyes, your next point.
Well, we need to get back to this point because there's elements there that I can argue. Number one, do you have my motions for a set aside complaint for defective equipment headlamp that were provided to the lower court per section 45.018?
I have the two motions that you submitted.
No, we need that from their court. So they denied me due process, and that's a violation of not providing all elements of the case that were argued, including the objections that I made within these original motions. So you don't have these motions, which clearly and articulately argue those facts that you have there at hand.
And you say arguing facts.
No, and I mean, we're discussing the fact of
Arguing facts is the purpose of trial.
Okay, hold on a minute. Now, in the hearing, each side is allowed to argue their point.
Mhm.
And then while one side is arguing the point, the other side will has to remain quiet, and they'll get an opportunity for what we call a rebuttal argument. Okay, so, and the other reason why I'm saying that is because, we have a court reporter here,
Shoot.
and she can't type down when everybody's talking at the same time. So that's part of the problem. Now, Ms. Reyes, motions that you filed in that court was filed in that court. You would have to file motions in this court if you want those motions to be heard.
The lower court is required to bring up the motions and the objections.
Okay, but that was you getting a whole new trial, right?
They still have to provide you with all elements, and there's nothing within the Texas Code of Criminal Procedure or the Texas Appellate Procedure that exempts them from providing all elements argued at the time of that trial.
Now, I would imagine that it is a lower court, a municipal court, is not a court of record.
That is correct, Your Honor.
Again, there would still be a court of record. Nothing exempts them from bringing up the record. There's nothing within codified anywhere that exempts them.
There's no requirement for municipal courts to keep a record, and the statutes already contemplate that. In that specifically in an appeal, a trial de novo is granted for municipal courts that do not keep a record. Specifically in Article 45.8.202 appeal, in section B, it's a de novo trial shall be held on appeal unless the appeal is taken from a municipal court of record and based on error reflected in the record, and that in and of itself acknowledges the existence of municipal courts that do not have a record.
Okay. So and now, Ms. Reyes, you may proceed.
So again, there's nothing exempting the lower court from providing the objections that I made at their trial. I requested a trial de novo because the way they ruled is not according to what is required by law. They did not hear any of the facts in my case at all. All they did was just deny my motions outright. They did not read my motions. They didn't provide me with any motions hearing as to the facts of the law that I have laid out for them. And I did a meticulous and analytical review of each element within their complaint, especially when it came to what they wrote in that complaint. That complaint is insufficient on its face. It does not have all the elements required. Okay, and then on that part, from that, after I did meticulous review of the codes that they alleged that I committed an offense, there was no offense codified within that particular statute that they used. And I have that here in my motions that I filed with them, which they should have brought up, because that is a violation of due process. Anytime anything's done in writing with the court, it still vests them with a responsibility to protect the due process of the defendant. And that was not done. So you won't know what to argue other than what's on their face. And it's not all the elements. You still have other elements within that that have to be met. Okay, so I did a meticulous review of that. It's right here in my motions that I did provide that court. And everything in that complaint is not stated. It does not provide all the elements. So that's my argument.
Okay. Now, Ms. Reyes,
Yes.
is that your final point, or do you have another point in your paper that you will be arguing?
Well, other than the simple review of what the statute, I mean, the primary and general rule of the statutory construction is the intent was the lawmaker found to be in that language. And so, for me, as a defendant, if it's not being read correctly or interpreted correctly, that's placing a burden on myself as a defendant to be held responsible for something that's not codified within the statutes as an offense. That's a problem, I mean, the Texas Transportation Code at 547.302C is clear that the general reference lamp was not singularly specific term headlamp. It just most certainly not the phrase two headlamps, according to what's in their complaint. That's not what the statute reads. At least one lighted lamp shall be displayed on each side of the front. Now, while the state and court are free to speculate what the intention of legislation was at the time of writing a statute that requires at least one headlamp be equipped on each side of the front of a vehicle, while at the same time not specifically requiring that those same two front equipped headlamps be functioning simultaneously. They may not insert that speculation in the language of the law as a requirement where the language clearly omits any supporting evidence of such legislative intent. Now, in the comparing material of the language of the statute makes it clear that the actual purpose of a headlamp in circumstances and conditions where other illumination is minimal or non-existent is not just to make a road ahead visible to a driver or operator or a reasonable distance. It is to make certain that their own motor vehicle is actually visible to others at a reasonable distance. And it is inarguable that the defendant's private automobile certainly was readily visible to the arresting officer at a reasonable distance as demonstrated by officers' actions in stopping and seizing defendant on and her property without a warrant or reasonable articulable suspicion and or probable cause. That is important because it's not in there. All the facts.
Defense says that, okay. First making the point that the defendant's motion that she's arguing from at this point is not before the state. And that we have not had the ability to review said motion. Secondly, her contention that the fact that her vehicle was readily visible to the officer in this case, this vehicle these are all, she says it's inarguable, these are all fact questions that will be best handled during the trial. In regards to the statutory language, the state maintains that the Texas Transportation Code correctly sets out the elements for this offense in this case.
Okay. Do you have another point to address in your motion?
Now, now, if there's a remote chance that an issue arises where the state asserts the aforementioned interpretation of the statute somehow does create an observed outcome or circumstance, then that moves court to take judicial notice and give careful scrutiny and consideration of the language of subsection 547.302A2, which clearly does not require the motor vehicle itself to be the actual source of illumination that allows persons, objects, or vehicles in or upon the roadway to be visible at a distance of at least 1,000 feet, and that it specifically states when light is insufficient or atmospheric conditions are unfavorable, which directly infers that light may come from any and all available sources of illumination combined to provide the required 1,000 feet viewing distance. And I discuss it further.
Mr. Hill.
The state would say that, of course, defendant is only pointing to 547.302A2, but in this case, we're getting into the facts of the case at this point, which I don't think is really the point of these types of hearings. But since we are getting dragged in that direction, I believe that the more apt part of the statute is 547.302A1. A vehicle shall display each lighted lamp and illuminating device required by this chapter to be on the vehicle at nighttime. She does reference to, but it is stated in the conjunctive in the statute. So it is in both of those times that those lighted lamps must be illuminated or must be on the vehicle.
They must be on the vehicle, but it doesn't state they should be illuminated. So the complaint alleges at 547.302A and C that requires at least 2 lighted headlamps, one on each side of the front of a motor vehicle. No such language exists within 547.302C. The language simply uses a general reference to any lamp required to be equipped by declaring at least 1 lighted lamp shall be displayed on each side of the front. Nowhere does the phrase 2 lighted headlamps appear in the statutory language, much less in relation to the terms duty, must, shall, or required.
Well, that's C, actually.
Thus, the state may not insert or infer into the language of the statute that which is clearly omitted by legislative design.
No, there's no inference or required in my part. It's verbatim what's in C. At least 1 lighted lamp shall be displayed on each side of the front of the motor vehicle. It is clear to the state that what's set out in the complaint and what's set out in the statute is sufficient in this case.
At 547.302, duty to display lights. A vehicle shall display each lighted lamp and illuminating device required by this chapter to be equipped on the vehicle at 1 at nighttime, 2 when light is insufficient or atmospheric conditions are unfavorable, so that a person or vehicle on the highway is not clearly discernible at a distance of 1,000 feet. B, a signaling device, including a stop lamp or a turn signal lamp, shall be lighted as prescribed by this chapter. And C, at least one lighted lamp shall be displayed on each side of the front of a motor vehicle. D, not more than 4 of the following may be lighted at one time on the front of the motor vehicle. 1, a headlamp required by this chapter, or 2, a lamp, including an auxiliary lamp, a spot lamp, projects a beam with an intensity brighter than 300 candle power. Now, in short, the complaint alleges an element of the alleged offense where neither the asserted element nor the offense itself legally exists. Thus, neither can be legitimately asserted or proven in a court of law or invest the court with jurisdiction of such a cause. It is axiomatic that a court cannot legitimately acquire subject matter jurisdiction of an alleged criminal offense that is not defined by and does not exist within any statute as pursuant to Article 45.019A4. One of the primary requisites of any criminal complaint is that the complaint must show that the accused has committed an offense against the law of this state, or state that the applicant has good reason to believe, does believe that the accused committed an offense against the laws of this state. Therefore, if no such offense is expressly defined by statute as it is required by section 1.03A Penal Code, then defendant could not legitimately and legally have committed an offense against the laws of the state, as there is no law of this state at issue in the cause. Now, while the state may wish to interpret 547.302A using a reading that purportedly requires that all equipped lights must be lighted at night, declaration about each lighted lamp, meaning any of the equipped lamps, not that must be lit. We know this to be true by the language specific 547.302A, 2, and C, which are the actual sections that should have been alleged in the complaint, but were not. So the meaning of the statutory text, when read, using the established canons of construction relating to such text, should have been plain to the legislatures who voted on it. We ordinarily give effect to the plain meaning. And that's Smith versus State. Also, where the statute is clear and unambiguous, the legislature must be understood to mean what it says or what it has expressed, and it is not for the courts to add or subtract from such a statute. Hoyt versus State, 1991, of course, quoting Ex parte Davis from 1967 and Boykin. Now, both the court and state are aware that, at least should be aware, under the rules under statutory construction and interpretation, a general declaration within a statute is always subject to and superseded by local and specific provision of the statute, unless the local provision specifically states that the general provision is to be controlling over the local. And that's at Texas Government Code 311.026.
Now, Ms. Reyes, the court has your motion in writing. So, as I mentioned to you earlier, do you have any additional arguments?
not at this moment.
Okay. State.
Can you please concisely rephrase what your last points were? Because there was a lot of reading there.
So basically, so what I was talking about at 547.302C.
Okay.
Okay, we were talking about what was out of those constructs from the legal language.
Can you point to the, sorry, if I know, can you point to me in your,
Right here, and this is in my statute. See, these are my motions for defective, which you do not have, which lower court is required.
Yeah.
Matt,
again, the state would re-urge that we are not, prepared to or going to argue on motions that are not before us at this point.
Okay. Now, Ms. Reyes, do you have anything else?
As I had I will reiterate what I discussed in the beginning. Based on my motion, I need in writing from the state their response to give me time to respond to their response to my motions in writing. This way it gives me time to respond to how they're seeing and viewing my information. And that way I can respond accordingly and have enough time to be able to do so and prepare.
Do you have anything else?
Not at this time.
Okay. So the court is going to take this matter in advisement, and this hearing is concluded. Okay. And so the retrial hearing in clause numbers 24 CCCR 2816 and clause number 24 CCCR 2817, both cases styled of state of Texas versus Helen Kathleen Reyes, are concluded. The court will take these matters under advisement. And so this will conclude the calling of the court's docket on today's date, May 30th, 2025, in County Court at Law Number 2 of Jefferson County, Texas. Judge Terrance L. Holmes presiding. Everyone, please have a blessed day. And Mr. Prosecutor, Mr. Huber, you are excused. Ms. Reyes, you are excused as well. And both you and Mr. Huber have a blessed day.
Thank you, Judge.
Well, guys, we've come to the end of this proceeding. And like I said in the beginning, it lived up to the hype of everything that I heard. First and foremost, all of this over a defective headlight. I mean, obviously, she was being defiant by not giving her license, not giving her address, not giving her name, which got her into more trouble. But, some of the same arguments, oath of office, subject matter jurisdiction. I will say there were some interesting arguments that she had in there that I had never heard before. And we'll get to that in a second. But, just kind of hearing everything she had to say, just seeing how the judge handled it. I thought he handled it well. This is the first time, though, that I've seen a prosecutor with the case of ums. I mean, we see a lot of sovereign citizens that's this, that. But this is the first time I've seen a prosecutor with the case of ums that bad. But we knew she wasn't playing any games because she came not only with a long 40-page motion, but she had a motion that had table of contents involved in it. So you knew that she meant business, by her doing that. And we see she referred to herself in the third person a few times. So even though she wasn't like super aggressive or whatever have you, she definitely had her sovereign citizen head on. And like I said, she made some arguments that I had never heard, and they sounded a little interesting. And I think that's why Judge Holmes said that, listen, we're going to take this matter under advisement. In other words, I'm not going to rule on this right now. I'm going to go back, take, everything that's been presented to me, the arguments, what she has to say, what the prosecutor has to say, and just take my time and really go through this and then, come back and render my decision later on. Now, I know some of you feel like no matter what a sovereign citizen has to say, it's just a bunch of garbage. But I can understand why the judge decided to go that route just by listening all the way through this and listening to some of the things that she had to say, because they definitely, to me, sounded interesting, even though I don't know law, but for the judge to not make an immediate ruling on those motions, they may have had, a little something to them. Who knows? We shall see. But as always, I appreciate you guys not only joining me, but sitting here, sitting through some of this commentary, which is never really a lot. I appreciate that. I appreciate you guys liking, subscribing, and sharing. It is always a blessing to the channel and to me. So thank you for that. And with that being said, guys, this is Sovereign Citizens Hall of Fame. And for now, guys, Sovereign Citizens Court is adjourned. I appreciate you guys. Catch you guys soon. And God bless.